Vasily Pavlov, and of Counsel Mr. Anton Svetoka, for the applicant in this case. Your Excellencies, I will speak first for 23 minutes, and Mr. Pavlov will speak second for 20 minutes. Applicant has reserved 2 minutes for rebuttal. For my part, I will deal with the first and the second issues, and Mr. Pavlov will then deal with the third and the fourth issues. With your kind permission, Your Excellencies, applicant would like to move to the first issue and respectfully invites this honorable court to find, firstly, that Raytenia committed internationally wrongful act, and secondly, that Raytenia is obliged to compensate for the damage caused by its internationally wrongful act. And moving to the first submission, that Raytenia committed international wrongful act. Applicant refers to the norm of customary international law supported by this court in paragraph 56 of its judgment in the case concerning United States diplomatic and consular staff in Tehran. And the norm is that international wrongful act of a state consists of a conduct which is firstly attributable to that state and secondly constitutes a breach of an international obligation of that state. Moving to the first element of international wrongful act, applicant would like to underline that Amelia claims the attribution to Raytenia of the conduct of Raytenia's Department of Resource Management, which is a state organ of Raytenia. And this is a norm of customary international law that the conduct of state organ is considered as an act of the state. It was supported in Salvador Commercial Company arbitration. Now applicant moves to the second element of the international wrongful act, which is...
Could you please specify what do you mean under wrongful act that in your opinion the respondent committed?
Madam President, Your Excellencies, and do you mean particularly the breach
Yes.
of obligation?
You
Yes,
said that
and
they committed the wrongful act,
yes, and
you're not specifying what they did.
In this connection, in this regard, applicant would like to underline that Raytenia violated its international customary obligation not to authorize any activity unless environmental impact assessment is undertaken. And the customary nature of this obligation was confirmed by this honorable court in paragraph 205 in its judgment in the pulp mills on the River Uruguay case. At the same time, it is necessary to underline that, as was admitted by the International Tribunal on the Law of the Sea in paragraph 149 of its advisory opinion in the concerning responsibilities and obligations of state sponsoring persons and entities with respect to activities in the area, that environmental impact assessment in connection with marine environment should address all the potential effects of the activity to the marine environment. And marine environment, according to the International Seabed Authority, includes inter alia natural and biological resources of waters, of seas and oceans. Hereby, applicant submits that Raytenia violated its customary obligation not to authorize any activity unless all the potential effects of that activity will be undertaken to the natural resources of the seas and oceans or to the waters of seas and oceans. And as is clearly evident from paragraph 23 of the compromise, environmental impact assessment for the Excelsior Island was submitted to Raytenia's Department of Resource Management. However, that environmental impact assessment did not include the effects of the construction of Excelsior Island to the natural resources of the Malachi Gap and to the waters of the Malachi Gap. And this is obviously the violation of customary obligation of Raytenia.
I have a question to you. The Malachi Gap Treaty says that both sides have the right to protect natural resources, right? You're saying this Environmental Investigation Act should have been done, signed, whatever, by the respondent. Don't you think that following the provisions of the Malachi Gap Treaty, you, as an applicant, as part of that treaty, had an obligation to do your own, to conduct your own environmental investigation?
Madam President, Your Excellencies, with regard to this question, applicant would like to underline that according to the facts of the compromise, Amalia tried to transfer environmental impact assessment of Amalia, which was conducted by the International League for Aquaculture. The environmental impact assessment was submitted to Rhytania's ambassador in Amalia. However, Rhytania's ambassador in Amalia refused to transmit that report to Rhytania's Department of Resource Management, which is also the violation of Rhytania's obligation to cooperate in respect of the activities in the Malachi Gap. Moreover, applicant would like to underline that Rhytania violated its obligation under Article 12, paragraph C of the Malachi Gap Treaty, particularly the obligation not to impair Amalia's right to exploit natural resources in the Malachi Gap by exercising its right to exploit seabed and subsoil in the Malachi Gap. And according to paragraph 27 of the compromise, Rhytania exercised its right to exploit seabed and subsoil of the Malachi Gap by authorizing dredging activities there in the Malachi Gap. And that dredging activities caused the halt of commercial exploitation of Dora and wrasse population, which is the fish vital for Amalia. And with this, applicant submits that by this authorization, Rhytania obviously impaired Amalia's right to exploit natural resources of the waters of the Malachi Gap. Now applicant turns to the second submission and submits that Rhytania is obliged to compensate Amalia for the damage caused by above-mentioned Rhytania's International Wrongful Act. In this regard, let us refer to the rule of customary international law that the state responsible for international wrongful act is obliged to compensate all the damage caused by that act. And the customary nature of this norm was supported by this honorable court by the Permanent Court of International Justice in its decision in Factory at Chozok case.
From which year this case is?
1928.
1928.
Yes, Your Excellency. And the particular damage which was caused by Rhytania to Amalia by Rhytania's International Wrongful Act is that Rhytania's conduct resulted in the beginning of dredging operation in the Malachi Gap, which in its turn resulted in the halt of commercial exploitation of Dora and wrasse due to the reduce of its population in the Malachi Gap. And the commercial exploitation of Dora and wrasse would have amounted to no less than $250 million annually from 2013.
Excuse me, how did you calculate this damage?
Your Excellency, this damage is supported and is evident from paragraph 50 of the compromise. And this is the calculation of Amalian Ministry of Trade.
Okay. What the percentage of GDP for Amalia bring this Dora and wrasse? Is Amalia commercially dependent on this?
Yes, Your Excellency. As is evident from paragraph 3 of the compromise, Amalia commercial exploitation of Dora and wrasse population constitutes a large percent of Amalia's GDP, and Amalia is obviously
Large percent is?
I can't answer your question, Your Excellencies. With this,
Is there any materials proving your words, or any investigations conducted by an independent authority? Because the authority that conducted this research that you're referring to is obviously, I would say, interested one.
it is true, Madam President, that Malian Ministry of Trade is interested in this question. However, according to the Compromis, International League for Sustainable Aquaculture conducted investigation of the effects of dredging activity in the Malachi Gap and stated that the population of Dorian wrasse was significantly reduced, and also that international organization admitted the need to halt the commercial exploitation of the Dorian wrasse. Consequently, Your Excellencies, applicant submits that Rhytania is obliged to compensate Amalia all economic losses, since those losses is the damage which was caused by Rhytania's internationally lawful acts. Now, with your kind permission, applicant would like to move to the second issue. And with this regard, applicant respectfully invites this honorable court to find firstly that Amalia is an exclusive owner of the wreck of the Kargast and its cargo. Secondly, that Rhytania's deployment of petrol vessels to the site of the Kargast was in violation of international law. And finally, that Amalia's salvage of the Kargast was lawful. And moving to the first submission, applicant claims that Amalia is an exclusive owner of the wreck of the Kargast under the flag state rule, which is a general rule of law as was supported by the United States Court of Appeals for the Third Circuit in its decision in the case United States versus Steinmetz. And according to the flag state rule, which is a general rule of law, a state under which the vessel sailed is an exclusive owner of that vessel and the cargo on board that vessel when two conditions are met. The first condition is that that vessel must be a state vessel of the flag state. And second condition is that the flag state has never expressly abandoned that vessel.
Do you understand it correctly that you're saying that the vessel was state-owned?
Yes, Madam President.
What is the evidence for this state ownership?
Your Excellencies, state vessel, according to the UNESCO Convention on the Protection of Underwater Cultural Heritage, particularly according to Article 1, Paragraph 8 of that convention, means the vessel which was owned or operated by the state and which was used for governmental and non-commercial purposes. And moreover, such vessel must satisfy the definition of underwater cultural heritage. And applicant submits that both these conditions for state vessel is satisfied. And the first one is that the Kargast was owned by Amalia and used for governmental non-commercial purposes of Amalia. And as was admitted by this honorable court in paragraph 60 of its judgment in the case concerning jurisdictional immunities of the state, commercial activity means activity which is exercised by private person. However, as is evident from the Compromis, the Kargast was under the command of state agent, which is not a private person. And the Kargast was under the command of Captain Baldric Rodriguez, who was a Malian explorer and cartographer, and acted under the letter of marque which was granted to him by a Malian king to bring glory to the kingdom of Amalia. And this is a clear evidence that the Kargast was under the command of state agent, of a Malian state agent, and exercised governmental non-commercial purposes. It is true, Your Excellencies, that the Kargast had some autonomy at seas. However, as was admitted in the case United States versus Steinmetz, when a vessel has considerable autonomy at sea, it doesn't mean that that vessel is not state vessel. Moreover, Your Excellencies, as is evident from the compromise, the Kargast meets the definition of underwater cultural heritage. And this definition of underwater cultural heritage is embodied in Article 1, Paragraph 1, Subparagraph A of the UNESCO Convention on the Protection of Underwater Cultural Heritage, which provides that underwater cultural heritage means the heritage which was underwater at least 100 years. And the compromise indicates that the Kargast was underwater at least 500 years, and therefore it satisfies the definition of underwater cultural heritage.
Is only the Kargast or the cargo, the artifacts from the cargo?
Madam President, according to the UNESCO Convention, underwater cultural heritage means the wrecks of vessels and the cargo on board that vessels. Therefore, the cargo of the Kargast, as well as the Kargast itself, is considered as the underwater cultural heritage. And since two conditions for the state vessel is satisfied, therefore applicant submits that the Kargast is a state vessel. And moreover, the Kargast has never been abandoned by Amelia, has never been expressly abandoned by Amelia.
May I have just one clarification? We are referring to UNESCO Convention. Does this convention somehow regulate the title to the cargo or to the artifacts?
No, Your Excellency. This convention regulates only the questions of the protection of underwater cultural heritage. Your Excellencies, since the Kargast is a state vessel and since it has never been abandoned by Amelia, then Amelia is still exclusive owner of the Kargast and the cargo on board of that vessel according to the flag state rule. Now applicant would like to move to the second submission under the second issue, and for that purpose applicant claims that the deployment of patrol vessels to the site of the Kargast was in violation of Rytania's obligations. Particularly, applicant refers to paragraph 11 of the preamble of the UNESCO Convention, which provides that one of the purposes of the UNESCO Convention is the cooperation in relation to the underwater cultural heritage. And following Article 18 of the Vienna Convention on the Law of Treaties, the party which is a state which is not a party to a treaty is still obliged not to defeat the purposes of that treaty. In this situation, Rytania is not a party to the UNESCO Convention. However, it is still obliged not to defeat the purpose to cooperate in relation to underwater cultural heritage. And this purpose is reflected in Article 10, Paragraph 7 of the UNESCO Convention, which provides that a state has obligation to obtain the consent of the flag state of the vessel before authorizing any activities directing at that vessel. In this situation, Rytania did not obtain the consent of Amelia for deployment of patrol vessels, being obliged to do so under the UNESCO Convention. Your Excellencies, if...
Do you think that deployment of the vessels somehow influences what you showed us as property of Amari?
Yeah.
Could you please clarify in what way did the deployment of the vessels violate the convention?
Madam President,